Item 22 from the...
We have to deliver the judgments first.
My lord. Apologize, my lord.
For delivery of judgment, Principal C case matter, Criminal Pet 1036 of 2026.
Petition is allowed.
Criminal petition number 212 of 2022.
Petition is dismissed.
Bail application number 3964 of 2025.
This one send it to my chamber afterwards, okay? Allowed.
Look,
Criminal petition number 35 of 2026 and criminal petition number 119 of 2024.
Both are dismissed. Yes.
Your Lordship, I was not aware that the delivery of judgment was there, my lord. Item 22 from the Part 2 list, my lord. It's a make appeal, my lord. It's a consensus prayer, my lord. If this can be taken up after a week.
Automatically.
Pardon, my lord.
Automatically it will come after a week.
My
Today is
lord,
the
yes.
last day.
Yes.
Okay, after a week.
Oblige.
Yes, may I seek your Lordship's indulgence in mentioning Part 2, item number 33. If this matter may kindly come up again after 2 weeks.
This was once mentioned earlier, I think. For Thursday. Which Thursday we don't know.
Okay.
But anyway, 33. List after a week.
Oblige.
For motion, item number 1.
may it please your lordship.
Yes.
Well, the petitioner herein seeks for the freezing of her bank account, which was freezed on 23/11/2025 by the respondent number 1, my lordship. The freezing order is at page 68 of the petition, my lordship. And my lords, the brief facts which led to filing of this petition is that, my lords, on 24/7 of 2024, 2.804 kgs of suspected heroin and 14.082 kgs of methamphetamine was seized by Special Narcotic PS. And then the case was later transferred to the respondent number 1. And it was registered as NCB crime number 5. Data, my lords. And then, my lords, during interrogation, Mr. MD Abu Saleh MD Saifuddin was.
So who is appearing for NCB?
Lordship, I will be accepting notice on behalf of NCB.
NCB. Hard learned counsel for the petitioner. So and so appears for respondent number 1, NCB. Formal notice need not be issued to respondent number 1. A copy of the petition be served if required. Issue notice to the respondent number 2. Returnable in 4 weeks.
My lords, I have an interim prayer, my lords. The allegation against me is that 31 lakh was
Anyway, they will have to file the response, whatever be the case. The respondent 2, I think, is only a formal party. They will have to abide by whatever. They are only the bank.
lost.
They are only acting under their orders. So 4 weeks is good. Okay. 4 weeks.
Yes, my lord.
So give it date. 4 weeks.
29th of September. Item number 2.
Lordship, the present matter pertains to seeking an appropriate order for the assessment of land compensation, my lord. The present petitioners are the landowners of Bolpuyech village, my lord. And prior to filing of this writ petition, my lord, an earlier writ petition was allowed by the coordinate bench of this honorable court by giving a direction for reassessment of the land compensation. Earlier, my lord, the situation is that the assessment was made as per the Mizoram Land Acquisition Act 2016. But by filing the earlier writ petition, the court passed an order for reassessment of the land compensation as per the Act of 2013, Land Acquisition Act or 2013. So, my lord, here the present petitioners are also in the same award, my lord. Award number 1 of 2020. Their names were not included in the earlier writ petition. So, my lord, we can say that this is a covered matter, my lord. So, prior to the formation of the Nathil district, the matter is taken up by the district collector of Lunglei district. The award is also made and passed by the district collector of Lunglei district, though presently it is under the Nathil district. So, Lordship, if your Lordship may kindly see the earlier direction which was annexed in the petition, my lord.
Who is appearing?
Your Lordship, I appear on behalf of my senior CGC, Ms. Aram Sangpui, for respondent 3, 6, and 7, and we may pray for time to take instruction.
You need to take instruction.
Mr. Lordship.
Otherwise, we couldn't dispose of by this. If when?
After 2 weeks.
After 2 weeks.
Mr. Lordship.
This is squarely covered, I
Yes,
think.
exactly.
Why do you need so much time for a simple matter? It hard. Counsel for the petitioner. Mr. So and so appearing for CGSC.
CGC, Ms. Aram Sangpui, for respondent 3, 6, 7.
It is submitted that the issue involved in the present writ petition is covered by the which judgment in order?
It's,
WPC 26.
yes, my lord, 26 of 2020.
Judgment and order dated 25/11/24 passed in WPC 26 of 2023. Learned counsel for the respondent takes 2 weeks time to obtain instructions in this regard. Hence, lays the matter again on. So we are not issuing any notice now. Let him get the instruction and we can dispose of it.
My lord.
Item number 3. Your Lordship, this is a contempt petition which has been pending since March of 2024. And Your Lordship, the respondents have filed an appeal against the order along with the condemnation of delay application. However, the division bench of this court recently has dismissed their appeal along with the condemnation of delay application. The court master, I've given the copy of the to the court master. So, Your Lordship, the delay has not been condoned.
Yes, so whoever, have the respondents appeared? All of
My
them?
lord, here I am appearing, my lord, for the respondents. My lord, the department has agreed to process the payment, my lord, and I have been informed today that within a month, my lord, the amount will be disbursed.
Okay. I think we can wait for that long.
Yes, if that may be reflected. in the
Heard
order.
learned counsel for the petitioner. It is submitted that the respondents had preferred an appeal against the judgment in respect of which the present contempt case has arisen, but the same has been dismissed by the division bench of this court. Before that, you write appeal has been preferred along with an application for condonation of delay, which has been dismissed by the division bench of this court in IA Civil 54 of 2025, right, order dated 11/8/26. Learned counsel appearing for the respondent submits that the respondents have taken steps to disburse the amount involved and the same is expected to be completed within a period of 1 month. Hence, list the matter again, give it date after 1 month.
First of October. Oblige, Your Lordship. Item number 4.
My lord, I'm appearing on behalf of my senior, Mr. Bilaramingwa. He's out of station at the moment. May this be taken up after 2 weeks to file AIO. Can we
File?
have 2 weeks time to file AIO?
What is AI?
My lord, they are here to file the outer affidavit by the respondents. In this case, my lord,
Not yet filed.
not yet filed. This is the fifth time of listing after they entered appearance in this case, my lord. And now the respondents 1 and 2 were the respondent authority under the MIDC, Mara Autonomous District Council. Here we are challenging the illegal appointment promotion of the private respondent 3 and 4. And despite notice, they failed to appear in respect of 3 and 4. And we are waiting for the affidavit of respondent 1 and 2. This is the 5th time of listing, my lord. Let it be last chance. Because the petitioners were in the verge of retirement.
Okay, heard learned counsel for the petitioner. Prayer has been made on behalf of the respondents for further time to file affidavit in opposition. Perusal of the record reflects that on several occasions the respondents have been granted time to file affidavit in opposition. However, having regard to the nature of the case, one last opportunity is granted to the respondents to file their affidavits in opposition, failing which the case shall be proceeded with. List again on 2 weeks' time. Yeah.
8 September.
Much obliged.
Item number 5.
Lordship, in the last occasion of this honorable court, and I was directed to serve a copy of the this petition to the newly appointed amicus, Lordship. If I'm not mistaken, I've already served a copy to the amicus. And Lordship, this may be taken up next week in the admission column.
Yes, his name is shown. I think. No, this is item 4, isn't it?
Item 4, Lordship.
Item 5.
Item 5. Item.
Yes, his name is shown. Our learned counsel for the petitioner. Yes, there he is. And Mr. so and so for amicus curiae for respondents 1 and 2. Copy served on you?
My lords, if it come before your lordships on Thursday.
Has the copy been served on you?
Yes.
Yes. Copy of the petition has already been served upon learned amicus. As prayed for, is the matter again on next Thursday.
No problem.
Grateful.
Next Thursday is for admission.
Lordship, in the admission column, then we can dispose it of it also, because it's
Admission hearing can.
yes.
Admission hearing can be done.
No, why I'm asking this is because Thursday would be the last working day. And
Oh,
we'll have very limited time.
Tuesday.
You can have it on Tuesday if you like.
We may try, my lords. We'll endeavor to have it.
Tuesday.
1st of September. Item number 6.
May I please, your lordship?
Yes.
Lordship, I am for the petitioner. Lordship, the respondent number 2 is to file their written objection, reply. But in the meantime, Lordship, I would like to pray for my interim order. At least the case at Champai may be stayed till proceeding of this case, because I am getting summons from this case. This is a petition for quashing of the order of the proceeding pending in the court of chief judicial magistrate.
On the last
Champai.
2 days you don't appear and today you come and ask for an interim order. Sorry.
Actually, I have appeared through virtual mode, but
It is
my
recorded
microphone
that none
somehow-
appears.
due to some technical error, Lordship, I couldn't find the microphone, the speak option, Lordship, for that only. I was already present.
Who is appearing for respondent?
Lordship, I am representing respondent number 2 and 3, and I have filed my the affidavit in opposition, Lordship.
Your Lordship, I represent respondent number 1, the state. However, Your Lordship, the state is, I don't know why they inflated the state, because this is between custom and petitioner. So we do not find anything. They have nothing to say.
Lordship, since the pleadings are completed, then we may try to dispose of next Monday.
So what is the matter about
Lordship, this is regarding the dry areca nuts. The
Areca
dry
nuts.
areca nuts, Lordship. This on
American nuts.
No, what is the stage now of the proceeding, impugned?
Lordship, the brief facts is that on 17 March.
No, I am not asking about brief facts. What is the stage of the proceeding
For
now?
appearance. For appearance, it is fixed for appearance, Lordship.
Appearance.
Appearance, Lordship. Lordship, in the reference case by this Honorable Court, it was already held that those areca nuts are not smuggled goods. In page 31, Lordship, 30 and 31. Page 31st paragraph, Lordship. Page 30. From beginning third line, Lordship. There is
No, this
May I
order
read,
pertains to what case?
this case.
This case.
After they have filed the customs reference case, it was held that the goods were smuggled goods. Then we appeared before the appellate tribunal at Calcutta. There it was held that the customs department could not prove. After that, customs department came to this honorable court by filing the reference case 1 of 23.
No, this page 30 you refer to is customs reference 1 of 23.
Yes, Lordship.
This is in respect of the same consignment.
Same consignment, Lordship. This is in reference to order dated 6/7/22 passed by the Customs Appellate Tribunal. They have come before this court.
So what remains of your
Lordship.
complaint?
The facts is that this dry areca nut was intercepted by the Assam Rifle personnels in the border of the Myanmar, and that was handed over to the Customs Department. And the order in original was passed by the respondent number 3, who is the commissioner, against the petitioner. And being aggrieved with the order in original order, since there is an alternate remedy under the Act, so they have approached the C-State Calcutta. C-State is Customs Excise Service Tax Appellate Tribunal Calcutta. And the C-State had set aside the order passed by the respondent number 3 in the IOI. And being aggrieved, the department have approached this honorable court by filing the customs reference. And the customs reference, in the customs reference petition, this honorable court has stated that since the department did not prove the dry areca nut was foreign goods, so it was dismissed. So, Lordship, now we have approached the tribunal, this trial court at Champai, trying to prove that there is a foreign goods, because there is a disputed question of fact. Because we say that this is a foreign goods, but the petitioner says that it's not. They did not prove beyond doubt. So we have approached the learned trial court. So now we have that criminal complaint was filed in the year 2023, Lordship. 2023. Criminal complaint number 23 of 2023 under 135 of the Customs Act. So interference of this honorable court may not be required, Lordship, because we may be given a chance to prove that that is foreign goods.
That, of course, this is not a final stage, but once two competent authorities have given a finding on facts that these are not foreign goods.
It's not like a foreign goods because we did not prove that it's a foreign goods. So
what is your case? What is your case in the trial? Smuggling.
The department intended to prove that this areca nut is a foreign good. So we have.
That is what, for the purpose of, he has made a prayer for interim relief. Since The weight of the judicial authority is that these are not foreign goods. So, prima facie, it appears you do not have much of a case there, and allowing it to continue, at least for the time being, would be prejudicial to the petitioner. So, likely we'll hear it, but I think we should not be dragged to a trial in the face of these findings already available at this moment until we decide this finally.
Understand.
Read heard learned counsel for the Mr. So-and-so, learned counsel for the petitioner through VC. So heard Mr. So appearing for respondent number
2 and 3 launch.
2 and 3. Learned
I'm a special PP launch. Special PP.
special PP for respondents number 2 and 3. The state government is not a necessary party in the instant case as submitted by learned PP, and hence respondent number 1 is not a necessary party. We'll strike it off.
Yes, Lordship.
Accordingly, the name of respondent number 1 be struck off from the cause title. Go to page 15, okay, 1-5. Para for Roman 1. This before that you write this application has been preferred seeking quashing of the criminal proceedings arising out of criminal complaint case number 23 of 2023 pending in the court of the learned Chief Judicial Magistrate Champai under section 135 of the Customs Act. Then you go to page 15, Roman 1 to 7, okay, except the last line. Then you continue, and the aforesaid order of CESTAT, CESTAT, was assailed in customs reference number 1 of 2023, and a division bench of this court has upheld the impugned order of the appellate of the CESTAT and held that there is no evidence to show that the seized areca nut was of foreign origin, by its order dated 01/05/2024, passed in the aforesaid customs reference. Para learned special PP customs submits that yes, what is your submission for today?
My submission for today is that
You have filed anything? No.
I have already filed my written objection or affidavit in opposition.
Submits that affidavit in opposition has already been submitted. full stop. Para learned counsel for the petitioner, on the other hand, prays for interim relief as the petitioner has received summons from the learned court for appearance. Full stop. Para having regard to the aforesaid facts and circumstances, comma, further proceedings in same criminal complaint case number 23 of 2023 pending before the court of the learned CJM Samphai are stayed until further orders. Is the matter for again on. We can keep it listed for hearing itself.
Listed for hearing, Lordship, yes.
It's the matter for hearing.
A date may be fixed, Lordship.
Yes, give a date.
25th of August.
All right. Highly obliged. Highly obliged, Lordship.
Item number 7.
Yes, Your Lordship, notice to respondent number 2 is returned and it is submitted that the address of the respondent number 2 cannot be traced out. And a copy.
So that is your instruction that it could not be traced out.
Yes. The police, the officer in charge as well as the village council, they have written that they cannot trace out the respondent number 2 in the written address. And they stated that she is nowhere to be found in Tenzol village.
What's that?
She is nowhere to found in Tenzol village, which is the address of the respondent number 2.
Father's name, mother's name, everything, they just all vanished.
But however, they cannot find out the exact address.
This PW, what is PW?
PW number. He's for the appellant. Actually,
Appellant.
notice is gone for the respondent number 2, who is the complainant.
I know he's the appellant. He should know who is the PW number of the respondent number 2.
Yeah, so the appellant.
What, you don't have a brief?
My lord, I'm appearing on behalf of the appellant counsel.
Yes.
I didn't bring any brief.
He has sent you to show your face.
Yes. He told me that he was received only the paper book.
Shall we record that senior counsel Mr. So-and-so has sent his junior to show his face
No, my lord.
without any brief? Who is your senior?
My lord, the learned counsel is actually my friend, my lord. I'm not in his team, my lord. He's my colleague.
There is no respondent number 2. Where is the memo of appeal?
The appeal memo is not shown. Respondent number 2 is Lalrin Pluangi, wife of Zhou Sangliana. The intervene.
Here it is just like this.
Yes, in the post title it is not written.
Where is the memo of appeal? This is the paperwork. Where is the memo of appeal? No, this is the judgment. You better appoint an amicus then.
Yes, Your Lordship.
Do. The address seems to be quite correct. But even
Yes.
phone number is there.
But they cannot find out. Even the village council chairman has written the acknowledgement stating that they cannot find out the
Like heard. No, just say that learned additional PP has submitted a report received from the officer in charge, Thenjol police station, stating that effort was made to trace out the respondent number 2. But as per report, the said respondent number 2 could not be traced at Thenjol, despite inquiry having been made from local residents, NGO leaders and the village council, and her presence, whereabouts could not be ascertained. Having regard to the above, I deem it fit to appoint an amicus curiae to represent the respondent number 2. Accordingly, its given name.
Your Lordship, he can appear for respondent number 2.
H. Zodin Sang.
H. Zodin Sang.
Okay. Is appointed as amicus curiae. Copy of the paper book be furnished to him. List again. Date after 2 weeks.
Obliged.
Right.
Item number 8.
My Lord, in this matter, I'm appearing on behalf of the appellant, and we have taken steps for service of notice upon the respondent number 2, and ID card has not been returned till date, my Lord.
You are appearing.
My Lord, I'm appearing for respondent number 1.
My Lord, if the registry may be directed to check the consignment, my Lord.
Huh?
The registry may be directed to check the consignment, whether that is delivered or not, my Lord. Because it is the second time we are taking steps, my Lord.
Who is the respondent number 2? Wow.
It's the owner, my Lord.
Owner.
Yes.
And you are claimant.
Yes, my Lord. I'm the claimant, the deceased mother.
So who has been directed to pay? Insurance company?
Yes, my lord.
Yes, my lord.
The appellant.
The appeal is in respect of what amount? Quantum?
No, this is regarding liability, my lord.
All right.
Since the deceased was the pillion rider.
So owner is not really necessary, is it?
Sorry, my lord. Owner may not be the necessary party, my lord.
Hmm?
May not be so necessary, my lord. The owner.
Because either you have to pay or you don't have to pay. Owner has nothing to do with it. If you are not liable, nobody is liable.
Yeah, since notice is not
Huh?
since notice is not completed upon the owner, we are
However, my lord, in a way, they are necessary party, my lord. If I may take your lordship to page 15 of the IA at para 16.
pay and recovery.
My lord, at para 16, in the middle, therefore, the OP number 2, National Insurance Company Limited, who is the insurer of the accident vehicle bearing so and so, is liable to indemnify the compensation amount to the claimant together with interest so and so from the date of filing of the claim application till realization.
This address appears to be
My lord,
not very descriptive. No, it just says resident of Chuvel.
my lord, before taking steps, I have contacted them that because in the record there was one mobile phone, so I was getting through them, and after that they told me that they can accept notice, and I also mentioned in the corresponding file also, my lord, the phone
So what
number.
to do now? Either we wait or you again. When was it issued? 37.
Yes, my lord.
So I think we can wait.
Yes.
My lord, if I may be allowed to file objection to DIA for condonation of delay.
All right. Third learned counsel for the applicant.
HW sir.
Applicant.
HW sir.
Respondent number 1 is represented by learned counsel.
Lalngai Sakifana.
Notice on respondent number 2 by speed post was issued on 30/07/26, but AD card is not yet received back. Await service. Respondent number 1 may file objection in the meantime. List again on.
My lord, checking of consignment, if it can be done or not, my lord, by the registry, my lord. That postal consignment checking, my lord. Sometimes they used to do from the registry, my lord.
All right, we can ask registry to furnish it, but
Yes.
sometimes that is also shown wrong. Registry to obtain consignment track report and furnish the same.
Give the oblige.
Oblige.
Item number 9.
Lordship, office note dated 19/8/2026 indicates that AD card is not returned from the respondents number 1 and 2. So we may wait for some more time.
AD card in respect of respondent number 1 and 2 not yet received back. Await list again on.
After 2 weeks.
Item number 10.
All of this matter pertains to An appeal against conviction under Section 25 1BA of the Arms Act read with Section 27 Arms Act read with Section 324 IPC. My Lord, we have received the paper book, and with Your Lordship permission, this matter can be fixed for hearing.
All right. Heard learned counsel for the appellant and learned PP. The paper book is ready. List the matter for hearing.
Obliged.
Item 11.
Yes, may please, Your Lordship, I am here for the appellant, and this matter come up for the first time, Lordship. And in this IA, we are seeking for 37 days.
37.
37.
There is private respondent. Or what? No.
No private respondents,
No private respondent.
only state, Lordship.
You can represent respondent 2.
I can represent respondent number 1 and 2. Your Lordship, I will not have, I will not file any objection in this 37 days.
No verbal objection either.
No. In the IA.
Yes. Heard learned counsel for the petitioner and learned PPM representing respondents number 1 and 2. This IA has been preferred, seeking continuation of delay of 37 days in preferring the connected criminal appeal. The reason for the aforesaid delay has been stated at paragraph 4, 5 and 6 of the instant IA, which has been perused. Learned PP submits that state that the respondents have no objection to the continuation of the delay. Having perused the reasons shown, this court is satisfied that the appellant was prevented by sufficient cause from approaching the court within the period of limitation. Accordingly, the delay of 37 days is condoned. I stands disposed of.
Obliged.
Item number 12.
Your Lordship, this is a bail application filed under Section 483 of BNSS read with Section 37 for release of the accused on bail. This has been come up for the first time. If the case record may be called for.
Why under 37 also?
It is a commercial quantity.
Yes, so 37 is the bar.
Yes.
So you are applying for bail under the bar. Hey, I have seen this practice in Mizoram only. Maybe somebody started this and everybody followed it, because 37 is not the provision under which bail is granted. It is
Correct.
a bar to the grant of bail. Commercial quantity.
Yes, Your Lordship.
Yes, where's the FIR? Today is fixed for what? Any CD is available?
Your Lordship, charge sheet has already been submitted as per the statement made by the petitioner. So a scanned copy of the TCR may be called for. This matter is listed for the first time.
Then why is it listed in orders?
Yeah, box here.
It should be listed in motion then.
Your Lordship, what they have stated in paragraph 11 of the application, they have stated that the investigation has been completed and charge sheet has already been submitted before the learned special judge, NDMPS. But my learned friend here is telling me that it's non-charge sheeted, so they will have to establish that fact because I don't know whether which to call the TCR or the case diary. They are not sure, but what they have stated in the petition is charge sheeted.
Your Lordship, it is a mistake. It is not charged.
What is the case number?
Excise case number 95 of 2026.
You could have annexed the charge sheet. Copies have been served to you.
Your Lordship, that is the.
Then we'll say the charge sheet TCR stroke CD.
But Your Lordship, with due respect, Your Lordship, TCR will have to be called for the concerned court, but case diary, it has to be from the police. So
Yeah,
it's
do
different.
both. One of them will say that if it has been filed, then TCR will come, and I will say we have filed. CD is there. Instead of having another date, since there is a categorical statement that
Okay. Direction may be given to the registry to call for TCR then, Your Lordship. And meanwhile, I will inquire
all
with
right,
the
since
police.
they have said it has been it's only because you
Because they have stated in their petition. but
raised some doubt as to whether it has actually been filed.
They have stated, but then now they're in writing, but then now they're saying that it's not charge sheeted, so I'm confused.
Already heard learned counsel for the petitioner and learned PP. This is an application for bail in connection with so and so case number. It is submitted that the charge sheet has already been submitted. Hence call for the scanned copy of the TCR along with the CD. List again on
17th of September. Anyone for hearing item?
May I please, Your Lordship, in respect of item number 35 of hearing list. In this case, my lord, I am the appellant. This is a civil appeal. I have spoke with the counsel for the private respondents, and since the rival parties were living in the same building, they were living in the same building, the rival parties, and we have the opinion that if the case may be referred to for mediation to attempt amicable settlement.
Achha. Don't say anything because no 35.
35.
He is not here. Right, in 35 hearing list that it is submitted by learned counsel for the
And for the appellant.
appellant that settlement discussions are going on for settlement and praise for adjournment. Hence, matter stands adjourned. List again after 4 weeks.
Make it after 3 weeks.
Yes.